Here's what you should know. There are two main types of car accident claims. First, property damage claims. These focus on the damage to your vehicle and any personal property. Compensation typically covers repair or replacement costs for your vehicle. Second, personal injury claims. These focus on the physical, emotional, and the financial impact of the injuries sustained in your accident. This includes medical expenses, lost wages, pain and suffering, and future treatment costs. Now, you have to understand fault and liability because it's critical in a car accident case. In an at-fault state, the person responsible for the accident or their insurance pays for the damages. In a no-fault state, your insurance covers medical expenses no matter who caused the accident. You can only sue the other driver in specific cases like severe injury. So determining fault is based on the evidence, like police reports, witness statements, and sometimes accident reconstruction. Proving fault is key to securing compensation in an at-fault state. So you have to file an insurance claim, though, to get the ball rolling. So after an accident, you have to contact the insurance company immediately, even if you weren't at fault. So there are two types of claims. First-party claims, which are filed with your own insurance company for damages covered under your policy, like collision coverage or personal injury protection. Third-party claims are filed with the at-fault driver's insurance company to seek compensation when they're responsible for the accident. Now, every state has a statute of limitations, which means a time limit for you to be able to file a lawsuit. This can range from 1 to 4 years, depending on your state, so be sure you know your deadline. If you miss this window, this could mean you losing your right to go to court and seek compensation. Don't forget, evidence is critical. You must collect as much evidence as possible from the scene. Take photos of the accident, the damaged vehicles, and especially your injuries. Also, get the witness contact information. You may not ever get a chance to see them again. Keep detailed records of your medical treatment, your repair costs, and your lost wages. Remember, documentation is key to building a strong case. And then, of course, the insurance settlement process. Just be cautious with initial offers from insurance companies. These are often lower than what you're really entitled to. So it's common to negotiate with the insurance adjuster and present evidence showing the extent of your losses to justify a higher settlement. Now, comparative negligence, that is, in some cases, where both drivers share fault. If you're partially at fault, your compensation may be reduced by that percentage. So, for example, if you're 20% at fault, your compensation will be reduced by 20%. Some states follow pure comparative negligence, allowing you to recover damages even if you're mostly at fault. Now, in a no-fault state, your personal injury protection coverage for medical expenses, that's going to pay your medical expenses regardless of fault. If a PIP doesn't cover all of your expenses, you may be able to file a personal injury claim against the at-fault driver. And then uninsured and underinsured motorist coverage. If the at-fault driver doesn't have insurance or has insufficient coverage, your uninsured or underinsured motorist coverage can help pay for your damages. While this coverage is optional in some states, it's highly recommended that you get it.